Welcome to part one of AASB's virtual summer law clinic webinar series. I am Shalicia Robinson, AASB's Assistant Director of Public Relations and the host of this session. Before we begin with our housekeeping items, I would like to take an opportunity to highlight one of our Platinum Sustaining members. Please take a moment to watch this brief message from American Fidelity. Being that this is a four-part webinar series, school board members will receive 1 hour of training credit for each webinar you complete. These hours help you fulfill state training requirements. All registrants have complimentary access to the webinar archives in the Law Clinic branch of School Board U. If you need help accessing the Law Clinic branch or School Board U, contact Whitney at sbu@alabamaschoolboards.org. She has also written instructions for you to follow, which we will send to you after today's session. Now on to the webinar. For our first session, we are joined by Chris Pape, shareholder at Lanier Ford Attorneys at Law. Chris will address the real-world legal implications of student codes of conduct and student discipline policies. Chris, they are all yours.
All right, I hope everyone can hear me all right. It's my first time using this particular type of web software. I think I've gotten so used to Zoom recently. So we're going to talk about discipline, some tough topics in discipline in about a half hour, which is not really enough time to cover, in detail everything that I know you all probably already know about student discipline. But we'll dive into some of the big topics and some that I think are particularly relevant and will continue to be relevant as school districts continue to have students using social media and likely continue to have blended learning and virtual learning as we go. So I'll dive right in. Again, I'm Chris Pape, I'm an attorney up in Huntsville, Alabama at Lanier Ford, and pretty much only do education law. So I'm very familiar with all this. So I appreciate all the difficulties you all have had in navigating all of these subjects. So what we're going to talk about today, I'm going to do a quick reminder of some procedural type things that I think it's always good to get a refresher on just, what are some of the aspects of codes of conduct, what exactly is due process, which is something you hear thrown around quite a bit. And then I'll talk briefly about some Alabama Open Meetings Act issues that pertain to student discipline. And then I will have a few fact situations that we'll talk through. I'll tell you, normally, I'm sad we're not doing this in person. Normally, I like to break my groups up into smaller groups and let you sort of form your own little school boards or work with your own school board members to tackle some of these issues. Unfortunately, you're just going to end up hearing me talk to myself, which, it's not, I don't mind doing it, but I do love hearing from you all and learning about how you all would tackle some of these situations. So we'll do what we can to make it as interesting as possible. Hopefully these examples will be pertinent. I will say I have a couple of tougher issues in my student fact patterns, particularly in light of some of the national issues that are going on right now. I just preface that to say that I think these are important issues. When we get to them, I think they'll make sense, but I feel like we'd be doing you a disservice not to address some of these issues. All right, so let's dive right in. All right, codes of conduct. So I can tell you in helping different boards around the state with developing and improving and revising and reworking their codes of conduct, there are several different forms that codes of conduct take. There are certainly some standard forms that quite a few boards use, but there are several boards that have moved to more progressive codes of conduct, some that have gotten away from the old class 1, class 2, class 3 codes of conduct. And really, you have a considerable amount of leeway in developing codes of conduct as a Board of Education. And I think you can really take your board's view of what is best for students and what is best for their full social and emotional learning, and making sure that they are able to have opportunities to not just be punished, but be punished and have an opportunity for intervention and supports. Because we know that when they sort of get fast-tracked over on the more disciplined side of things, that academics suffer, students miss days, all those things have both implications on the student's future, of course, and also your report card grades for your district. So that's all very important, both from an academic and then from an external viewpoint. And there are some limitations, and I won't dive into a lot of detail about what I've included on this slide, but there are some limitations on your codes of conduct in terms of some state law and some federal law about certain things that you need to try to cover at a minimum. There's statutes concerning firearms and drugs, and there's a federal act, the Gun Free Schools Act, I've included here, that has some guidance about codes of conduct and related to firearms on campus. Also, there's some regulations in the Alabama Administrative Code talking about restraints and seclusion, to the extent that restraint gets used as a punishment, or which it shouldn't be, but might need to be used to break up a fight or something like that. The Alabama Administrative Code limits what is acceptable in terms of the types of restraints and things you can use. For instance, mechanical and chemical restraints like handcuffs and pepper spray are not to be used. So there's more to it, but that should give you at least a little taste of some of the statutes that limit codes of conduct. Okay, student hearings. Just like codes of conduct, these actually look very different around the state in terms of what different school systems will do. You have some school systems that will have a hearing panel of administrators who will determine whether or not a student is innocent or guilty, or however you want to, whether they committed the offense or not. Sometimes that's then appealed to maybe an individual, like a deputy superintendent or superintendent. Sometimes that's appealed straight to the board. Sometimes there's lower level committees for if it's like a 10-day or a 20-day suspension or a very short-term expulsion. And it never gets to the board. Sometimes if they are sent to the alternative school, it never gets to the board. Sometimes the board is the first group that hears of a student's discipline, and it just goes straight there. And so again, kind of like with codes of conduct, there's a lot of leeway in finding the best process that works for your district. And you can even have different number. You see the second bullet there, I talk about several layers of appeal versus a single layer. You could have it where you have a committee that then a parent could appeal to a higher level district administrator with a final appeal to the board, for instance. That's acceptable. So, you know, there's certain nuances for how it should be done, and I definitely, you know, recommend working with your kind of local council when you're doing this, because it's important to make sure you get that process right, but you do have some options. So why do we have these hearings to begin with? The main concern, and I'm sure for most of you, this isn't the first time you've ever heard of it, but the main concern is something called due process. And so I put some language there from the 14th Amendment. So the government, which is the school board, is not to deprive any person of life, liberty, or property without due process of law. Okay, so that's one of those things that, unless you've gone through law school, doesn't really mean anything to lay people. They've heard it, people have heard due process, but what does that really mean? So I put the three very high level requirements on the slide of what has to occur for you to comply with the kind of the baseline due process, procedural due process concerns. So first is notice. This is notice both as to what conduct would be acceptable in a school environment. So we need to make sure that your codes of conduct do a good job of explaining what kinds of behavior are considered appropriate and what kinds of behavior are not considered appropriate. So that's really the first step. It's kind of like having a criminal code, or even if you think about a speed limit when you're driving down the highway. It's giving you notice of what is the acceptable conduct is. Now, when a student violates that code of conduct, they also have to be given notice of the, I hesitate to say charges, against them because I don't like conflating the criminal law with student codes of conduct, but because it's easy for people to understand, you have to give them notice of the charges against them, what they did wrong. So if they were in a fight, you have to let them know the reason for your proposed punishment is because you were fighting. So then following that, you have to give them a right to be heard. Okay, so the right to be heard is very important. It's the opportunity for the student to be able to tell their side of the story. And it needs to be before, I wrote neutral tribunal. It can be a neutral decider. It doesn't have to be a group per se, because the amount of due process that you get, the amount of hearing that you get depends on the level of your deprivation. So what do I mean by that? If you're going to be suspended for a day, your due process is not going to be nearly as extensive as if you're being told you're going to be expelled from campus for a full school year. Then you need considerably more due process protections, and you will have more procedural rights. So what does this look like in those two scenarios? If I'm going to be suspended for a day, that can be as simple as this. This would be due process. Principal comes, pulls a student out of class, says, I've heard you were in a fight in the bathroom with Johnny. What do you have to say about that? The student says, well, I didn't fight with Johnny. It's made up. The principal, maybe because they've got Johnny's statement or they've seen a video camera or something that shows that they believe that the student is not telling the truth, can then decide, I don't believe you. It's my view as the neutral decider here that you did this behavior, and I'm going to give you a day of suspension. There, that student got notice, had a right to be heard, and then they had a neutral decider in the principal who heard all the facts and made a decision. Now you contrast that with something serious like maybe bringing a gun to school that's going to go before the board on a due process hearing. You may have attorneys for both sides because and take testimony from both sides and have it seem more like a formal proceeding, because the penalty there could be missing, a full 180 days, an entire school year worth of education versus missing one day in my other example. An interesting little wrinkle is that when you send kids to alternative school, there's a question about whether or not that even requires due process. So you have a little more leeway in terms of if your alternative school truly does provide similar education to what your general school environment provides. There's some, I would again recommend speaking to your local council and not just cutting out any sort of due process to the student, but you might have a little wiggle room about how stringent your procedure has to be before you place a student in alternative school. So just something to think about. All right, the Open Meetings Act. I won't spend a lot of time on this. I think everyone is pretty familiar prior to, I guess, COVID-19, and there, so obviously there are some differences as long as the governor's orders in effect, and who knows what will look like in the future. But prior to all this, the deliberative process of governmental bodies was supposed to be open to the public, with the exception of certain subjects that can be talked about in executive session. So do student hearings have to be in public? No. So I went ahead and included the executive session language here. You see I have an underlined part saying that student at public school, if the board is going to consider discipline or dismissal, you see the language there of a student at a public school, you can hold an executive session to make that determination. So that's just a reminder about some of the Open Meetings Act language. I put in the last slide, I'm gonna bounce back here, I put what about FERPA? And although I put it in the context of open meetings, I just remind board members that as we move forward into this future where there's going to be more Zooming and online learning and virtual learning, as there might be spreads of the coronavirus and schools having to close, that you might see maybe more publicly than you would have seen in the past behavior of students, or hear about behavior of students that might be subject to discipline. So in the past, you might have heard of a fight at school and you ask your superintendent about it. Your superintendent should tell you that he can't really talk about it. He or she can't share that with the board for a couple of reasons. One, if it's something that could come before the board, you don't want to be exposed to it before you are a part of the due process hearing. But two, under FERPA, a student's discipline record usually will be a part of their educational record, and therefore you do not have, even as a board member, a right to see that unless there becomes an educational need for you to see it, such as being a part of a due process hearing. So, you might have had that before, where you reach out to a superintendent and they're kind of, they sort of say, I can't really talk to you about that. Well, you might have that even more often now, where it will get a little confusing, and superintendents will have to work through this, because some of the behavior will be posted maybe on social media or something like that, where everyone in the community is talking about it. So these will be some difficult topics that superintendents and boards will have to navigate, and not running off and doing their own, especially board members. I don't encourage you to go do your own investigation. Even if something does pop up on social media, leave that to the district and the superintendent, so that the superintendent can then present a case to you if something big happens on social media or during a Zoom. Even if people kind of are a buzz about it, let the district and the superintendent sort of run with it. Okay, so these are examples based on real fact patterns. All the identities of the students and even the couple of pictures I have in here are made up. Like, I found them on the internet. They're not real people, and I will not identify the clients that we did these fact patterns for, but these are based on very real situations. Okay, so student 1 in our first scenario here, Marcus is an 8th grade student at a local middle school, usually well behaved, but was recently involved in a fight. Normally I would give you more details about the nationally covered school shooting event, this 420 iron shooting that I'm referencing here, if I were giving this to you as a small group. Just assume that there was a really, for the sake of this example, a really bad school shooting. Students lost their lives. Say it happened on a Friday. It was a very tragic, terrible situation. But then Marcus, over the weekend, posts the following picture with no comments that you see on this next slide. No comments at all. So it's just that picture gets posted over the weekend of a student. Again, this student is just a picture off the internet, not a real student from any of the schools that we represent. But within minutes of this post going out, you get school officials start getting calls and texts. The principal of the school, of Marcus's school, starts getting calls and texts from parents. What do you do? So this is an opportunity to talk about different codes of conduct real quick. There are kind of 4 different types of codes of conduct. You have sort of a pure zero tolerance. If a student does the crime, they get whatever the penalty is all the time. Same crime, same penalty, same act, same penalty every time. Sometimes you have a zero tolerance where there's a little more flexibility in the punishment. So if you do the act, you're either going to get expulsion or alternative school. So maybe there's a choice instead of just always expulsion. You also have some open-ended progressive discipline codes of conduct that you can use. And I actually tend to prefer these, because progressive discipline allows you to escalate consequences and supports as a student repeats behavior. There's both kind of an open-ended progressive discipline approach. So this is, if a student does a particular behavior, they're punished progressively. So if they do it the first time, it's a lower punishment. And if they do it the second time, it's higher, and so on. If you have a pure open-ended, you can just have a list of offenses and not really give specific levels or assign consequences. I think that's complicated and hard for schools to implement. So I prefer the guided progressive discipline, which is where if a student does the act, there are a preset number of steps, like first time it's this penalty, second time it's this one, and so on, until the student does something or repeats it enough times that eventually they would receive the highest level of consequence. So going back to our example, let's assume that you have one of these guided progressive disciplines, saying that if you make a threat targeted at the general school population, administrators have the discretion to begin at a level 3 or 4, depending on the threat and the disruption to the school environment. So that's our code of conduct for Marcus. Let's assume that a level 3 could go up to in-school suspension for 10 days or out-of-school suspension for 10 days. Level 4 could allow the student to participate in what's called restorative justice process. I highly recommend reading up a little bit more about this. For the sake of time, I don't have a lot of time to talk about it, but I put a link there for you to read about. Assignment to alternative school or expulsion. So these are your level 3, level 4, and so you have different options or steps to follow for the punishment. So this is where we're going to talk about an issue that I think is important. When you were considering those codes of conduct on this last page here, level 3, level 4, the student just posted a photo with the handgun right after the shooting. Okay. The question is, what if another student during that same weekend, or if Marcus was this student instead, holding a rifle instead of a handgun? Should, again, no comments, just this picture. Should the two photos result in the same punishment? And my advice to you is yes, both students should result in the same punishment, if to the extent you're going to punish either student, because both of them are students holding firearms. Now, I would argue actually that this isn't necessarily a threat at the school population because it doesn't have any text with it. It doesn't have any extra communication about what you're going to do or what they plan to do with the gun. I guess what I'm saying is you're going to walk a fine line between what is considered student speech and what is actually an off-campus threat made to the whole school population. Earlier, I was talking about notice. To help clear some of this stuff up, I definitely think it's worth having like a jurisdictional statement in your code of conduct. Something like, the Board of Education reserves the right to punish students for off-campus behavior that causes or threatens physical harm against a student, a school, or personnel, or something like that. That makes it very clear in your code that you have the ability to punish students. In this case, with just the picture, it's hard to necessarily tie a threat to that, to the school. What I would say instead is if there were maybe some language at the bottom, like looking at my school, or, I'm coming for you, or something like that, some extra language that shows some hostility, then I'd say you'd be safer and less likely to run afoul of the First Amendment. But I just point this out because I've dealt with this several times in different districts, that if you are going to punish and you think it does rise to the level of your code of conduct, you do have to be careful of First Amendment, but you also need to treat students who might be culturally from different backgrounds the same way. Not doing that can get you in trouble for different reasons unrelated to the First Amendment, especially for many of the school boards that might still be under active school desegregation cases or any sort of other OCR investigation. So I just point that out as something to have on your radar. Okay, I'm going to sort of do a quick, like 2 minutes on my second scenario here, and then spend more time on my third scenario. Second scenario is Marcus again. He's causing trouble. Marcus seems to always be causing trouble in all my examples. So he's an 11th grade student. He wants to be a rapper and a music star. He has a YouTube channel, although now it's probably more likely to have like a TikTok or some other social media where he posts his music videos. School officials are notified that Marcus posted a song while off campus outside of school hours that appears to be threatening. I apologize. I did star out some profanity here, but just to capture the example that we had in one of our clients. So these are the lyrics in one section of the song. You see it mentions having a gun and going, he had dark thoughts in his head, gonna go to school. It's very violent, okay? No question that this is a violent song. So if your particular district has a zero tolerance for violent or threatening behavior, and here's an example of the no tolerance. Any student who makes a threat targeted at the population shall be punished by expulsion or assignment to alternative school. So both those are very harsh. It doesn't give a lot of wiggle room for lesser punishments. So here, this is kind of your introduction to First Amendment. And then the last example, I'll spend a few more minutes going over First Amendment examples. But this is a First Amendment issue. Funny enough, the song lyrics that I posted were actually from another artist, like a famous artist, and it's this particular case turned out to be a cover. It was a cover of another artist's song. It was not an original work by the student. Okay, so that is clearly artistic expression. He's covering another nationally famous artist's song about school shooting. So those kind of situations should immediately trigger your mind if you're a school administrator. This might be a First Amendment issue because they're talking about artistic expression here. So I put some examples under this First Amendment or the test, this three-part test. I'm going to skip over it because we're going to come back and talk about each one in the next situation a little more with a little more detail. But I will just remind you guys listening, anytime that little alarm bell goes off, it's First Amendment, please speak to your local counsel, or at the very least, if you're a principal, reach out to your superintendent or your supervisor, because actually, if you violate the First Amendment by punishing a student for a clear violation of the First Amendment, it's actually personal liability for the individual, meaning that it comes out of their pocket, not the board's. So I just remind everyone of that. It's very important to take those seriously. Okay, so what should you do? In this case, it's probably going to be protected by the First Amendment. So you could call the student in, check on the student, make sure everything's okay. But I'd say you're walking a fine line to punish them for their YouTube content, especially if it's a cover song of another artist. All right, last example. So Dell and Marty are seniors at your local high school. During the previous year, when they were juniors, they recorded a video of themselves in costume. One of the students, Marty, was wearing swastikas and using racial slurs. The students did not post or share the video during their junior year. So they did this during their junior year, and it wasn't released. However, during the break caused by COVID-19, Dell and Marty had a falling out. In retaliation against Marty, Dell decided to release the video from the previous year on social media. Students at the school became offended by the racially charged video, and students organized a march around the school even though it was closed. The principal and the administrative team began investigating the actions and now have to take action. So your code of conduct contains prohibitions against making threats that you see here based on a student's race, or harassment based on race or any of these other characteristics, or using profanity or offensive language. So first, which offense would apply? I think honestly you could use either. You need to be consistent. It seems like it's probably more likely to be the second, because it would depend on the nature of the video that they released, if it was actually threatening language in the video or if they were just generally using offensive language. This is going to be fact intensive. One or both of these offenses may apply. It just really depends on what the students were saying in the video. But we're going to do a quick 3-minute crash course so I don't take up too much of my co-presenter's time on the First Amendment. Okay, so before you can punish a student, you got to meet this test. There are a bunch of different tests, and I could do a full session on First Amendment, but at the minimum, you need to look at this test. So first, is there a sufficient, we use the word nexus, what we mean is connection. Is there a sufficient enough connection from the student's off-campus speech to the school? Okay. Second, is it reasonably foreseeable, or is there a foreseeable risk that the speech would reach the school and the school officials? So is it aimed at the school, and is it likely to get there? And then if 2 and 3 are met, you have to see how disruptive is this going to be to the school. Let's look at our example. Okay, so is there a sufficient connection between the speech and the school? Well, in this case, it took place off campus and was recorded a year earlier. So the speaker of the racial slurs doesn't appear to have intended for the language to get to the school, because if you remember, Marty did the speaking, but Dell got mad at Marty and released the video without Marty's permission. Does that matter? As a matter of fact, it can matter. There have been cases around the country where if a student wrote in their diary, for instance, some really, dark thoughts about how they were going to cause violence at the school, and maybe their sibling found that diary, took it to the principal, and kind of ratted out their sibling about their diary, there have been cases where the courts have said that there's not a sufficient connection. There wasn't an intent to have that speech be directed at the school. That was private speech that was not directed at the school. So there can be times where the intent of the speaker matters. So my third point there, how do things change if the student intended to send the video? Well, your case gets a whole heck of a lot stronger, because there's pretty much a rock solid connection between the speech and the school. If you send it directly, let's say instead of posting it on TikTok or Instagram or some social media, they send it to like a GroupMe or a class chat, like a senior class chat or something like that. Well, then it's much more likely that they were trying to connect the speech with the school. Okay, so our second one, is there a reasonably foreseeable risk that the speech would reach the school? Again, this took place off campus, and they did it while they were just, let's presume they were hanging out, doing whatever when they recorded the video. And as I just alluded to, this was posted to social media. So let's say, on TikTok, Instagram, Facebook, whatever. Is that likely to reach the school? In this day and age, it probably is likely to reach the school, just given that the peer group of students is likely to be connected through social media. So, nowadays, I think the analysis is going to get pushed further and further that if you post it on social media, it was likely to, or there was a foreseeable risk it would get to the schools. Maybe 15 years ago, when early Facebook time, that wasn't the case. And I included here, how do things change if the student sent the message to other students directly? Well, I think your case, again, is a whole heck of a lot stronger because you will have evidence that they were trying to direct their statement to the school. It's more than just a foreseeable risk. It's almost a certainty that if you send this video to the other students, it's going to get to school. So even if you have those first two, that's not necessarily enough unless it's reasonably likely to lead school authorities to think that there will be a substantial disruption or that it will materially interfere with schools. So what you're looking for here is something that causes the schools to be unable to continue education, or maybe a big, like a fight or some sort of big a walkout, or there could be this could take so many different shapes. It could just be a disruption in a classroom, one classroom that gets disrupted. In this case, I made it a little easier for you because I explained that the students decided to march, even though the school was closed because of COVID-19. A student march, you know, whether or not that interferes with school is an interesting question. So clearly it was a big event, but if the school was already closed, was it really disrupting school activities? That's a good question. It's one we'd have to work through if this actually presented itself. If the kids chose to, if we were in school and chose to walk out and march, clearly that would be a disruption. There is case law out there that explains that if administrators are having to spend their time responding and investigating to a situation, that may be enough to disrupt the school activity. So if those administrators aren't able to help their teachers deliver the virtual instruction because they're spending all their time investigating this, that might be enough. So again, there's a lot of wrinkles about how the First Amendment plays, which is why as we move forward with all this social media, we have to be very, very careful about how quickly a school acts to drop the hammer on a student. It's often better to try to dig a little deeper, get more facts, and there may be ways to remedy the situation through interventions, supports, or getting the students together than it is to just immediately go for expulsion or do a board hearing. All right, so my last slide here, because I've gone over. Oops, I'm sorry. My last takeaways for you all, make sure you understand how your code of conduct applies to the situation before you. So you want to read all the offenses that could apply, really make sure that you are looking at an offense that applies to the code. As board members, always try to remain neutral. You're not the investigator. Consider only the evidence that's put before you. Should you find yourself in a hearing, trust that your superintendent and their team will do the investigation. Always keep in your mind the principles of fairness and equity and the dangers of implicit bias. We have to be very vigilant that we're treating all students, regardless of race, in the same way, and that we're protecting all of our students. So if its consequence would apply to one student's behavior, it should apply to other students, regardless of their demographics. Always remember First Amendment. That's going to become a huge battleground as we move forward dealing with school closures and virtual. And then I just say consider the benefits of alternative school versus expulsion. Alternative school students continue to attend, and you also don't necessarily have the same procedural due process risks that I mentioned earlier if you keep kids in alternative school as opposed to expulsion. So anyway, that was a lot of information. I hope that was helpful, and I'm happy to answer any questions that pop up.
Thank you so much, Chris, for that great information. I see we do have one question. Let's see, it says, great presentation, Chris. When considering two students accused of the same conduct, should they receive the exact same punishment, or should there be some consideration of other factors as well, such as does the student have a disciplinary history, does the student admit to the conduct, or did the student's attitude demonstrate that they were sorry?
Yeah, so a lot of the codes of conduct, even the one that I'm more of a proponent of in terms of the progressive discipline, where you have like the steps, uh, where like the first time an offense occurs, you might receive a lower level, and then it increases as you go. I do think that the beauty of those sort of codes of conduct is that they do look more holistically at a situation. So if you have two kids that's got into a fight, and it's one of the kids' third time to be in a fight and the other kid's first time, in a progressive code of conduct, they won't actually get the same punishment. One of them would get a stiffer punishment because it was their third time. Whereas the other student, this might be their first offense, they'll have a lesser punishment. I do think you should take into account some of the external situations. You just have to be very careful that if you do take into account, you know, a particular student situation, that you are willing to take in similar facts about another student. You don't want to say one student comes from a good family, I know that family, that was probably an accident. The other student whose family you may not know, and you say, well, I don't know them that well, we'll just give them the punishment. You just want to be fair whenever you can. That will really minimize your risk of having inadvertent discriminatory conduct. But on the whole, I do think it's important to look at a student's whole picture.
Thank you so much for the awesome presentation. Now
Yes,
on to our next session. Sarah Young of Stone Crosby PC, Attorneys at Law, will cover the responsibilities and liabilities when dealing with bullying. Sarah, they're all yours.
All right, so what better way to spend your lunch hour eating a sandwich talking about guns and student discipline, and now the always topic, readily talked about topic of bullying. So I want to start today with just why as a board member do we need to talk about bullying? And I guess I probably should phrase it as, when do we not hear about bullying? But I think that, the reality is that bullying is a hot topic in the nation, especially right now, and it can be very costly for board members and the board itself and the school system. So I just want to share a couple of examples I've highlighted in the notes, things that stick out to me, which is all across the country. When you get a bullying lawsuit, you've got hefty fees like settlements of $295,000. Not only could it result in a lawsuit, but it could result in state administrative complaint processes and investigations that could result in a hefty amount of funds having to be spent to address bullying, systemic bullying issues in your school systems. I always tell my client that when OCR comes knocking, it's usually never good. And that we want to avoid that process as much as possible, because we're on the hook to resolve the issues that OCR might find. And as you see in this example from this news article, it can result in up to $8 million worth of services and implementation that has to be done. I've highlighted here, it affects all kinds of individuals. You've got race issues, gender issues, and the one that I tackle a lot, which is students with disabilities. So you could be on the hook for things like, we hate as lawyers seeing the word punitive damages. And we never want to see that, because that usually has a big dollar sign attached to it as a board. And I know our CFO doesn't like to see those dollar signs either going out the window, when we could be spending those on student services. And if you think it doesn't happen in Alabama, I've included a few examples of it. It does happen. This one is local in Southern Alabama, where they sue, and now these are just allegations, but they sue not only the Board of Education, they're suing the superintendents, the principals, head football coaches, and of course, hefty price tag. And then this one was the most recent one I found as I was just looking through issues of, what's happening around the state. We know that student suicide is an issue. Typically when student suicide happens, parents are looking for someone and a reason why. And a lot of times that happens because of the student was bullied. So this was a recent one that has happened in our state. So some questions as a board member. I usually present this to administrators and employees, and it's almost more of a scolding and a overview of what all the laws are, and a remedial issue of this is how we're going to make it better. So for board members, I'm thinking, what is your role? And I asked some of our board members, what would you want to see discussed as a board member, as kind of a top layer up top? What would you like to know about bullying? And I think one of the biggest concerns is what is and what is not bullying. We use the term so often these days that everything seems to be bullying. Anybody that's mean is bullying. So I want to go over what is and what is not bullying. An issue that I see in the school systems is just thinking that one law applies when it comes to bullying. And we're going to talk about today that there are many laws that unfortunately our educators and our administrators have to think about when someone alleges bullying. And then what is your responsibility as a board member? So what is bullying? It's not just mean girls. The definition from bullying.gov talks about it is aggressive behavior from one student. And of course, they don't define what aggressive means, but I went to Webster's dictionary just to pull some ideas on what is aggressive. It's pushy, it's insistent, it's unprovoked. It's a person that is doing that and being confrontational for control. So bullying is aggressive behavior that represents an imbalance of power. So it's not just a group of friends and I inadvertently, don't invite somebody to a party. It is, I am being confrontational, it's unprovoked, and I'm doing it because I want to be in control. I want to embarrass you. I look down on you. And I think the key definition to me is it's repetition. It's repeated behavior, or it has the potential to be repeated. So it is threats that are made to the student. If you do X, if you show up at school tomorrow, I'm going to beat the what out of you. So the bullying.gov website goes over the different types of bullying. They highlight, this could be verbal, just teasing, name calling, social bullying, where you're leaving someone out, you're spreading rumors about someone, you're embarrassing them in public. And sometimes it gets to the egregious level also as hurting someone physically, hitting, tripping, and making rude hand gestures. Let's see. What about cyberbullying? I think bullying has been around for forever. But I think with the emergence of all the different social media and all the different apps that kids have access to these days, and the way that the apps work, it has really highlighted and taken on a new level of bullying. The bullying doesn't stop when kids leave the school building. It continues on. And I've just given some examples. These are no students. I just did a Google of Facebook, Instagram. I mean, I have seen Instagram hate pages for a certain person or a certain teacher, and the entire account is just hating on that person. So that brings the topic of what is cyberbullying? Is cyberbullying bullying? Stopbullying.gov and a lot of different states. Alabama does not actually go into detail on what cyberbullying is, but we do include cyberbullying in our new bullying law. But bullying done through any use of electronic communications device. So that's the computer, that's through any of your social media, any of your cell phone apps, going onto a blog. I don't even know if people go onto blogs and comment anymore, but any form of electronic bullying. And I think, as I discussed, the hard part about cyberbullying is it's persistent, children can't get away from their cell phones and digital devices. Kids have that. When I was in school, you know, I went home for the day. I didn't have a cell phone. If you wanted to have access to me, you had to call the old landline. My kids don't even know what a landline is anymore. So students have persistent access to their friends and their peers. Sometimes it can be permanent, and so it lasts. It's their reputation. You can Google that person's name, and you may get 1,000 Facebook posts that mention, you know, negative information about someone. Sometimes I noted that it's not permanent, and that's what makes it harder for administrators to discipline and investigate those instances, is that you have apps like Snapchat or whatever's out there these days where things disappear. So kids can be bullied and then it goes away and they don't have proof and they don't have a way to show their administrator that it's happening, so that they can take discipline. And it's hard to notice. It can go on in the classroom and a teacher doesn't have knowledge of it. It's not a physical fight that the teacher can intervene with. It's going on, you know, behind the teacher's back. Okay, so this is the big umbrella, and kind of like Chris said, I mean, 30 minutes is really not enough to dive into the weeds. So I want to hit these, and then hopefully you have the handout with the PowerPoint slides, and you know, you can go back through and access some of this information. But I think the gist of what I want you to get out of this today as board members is that we have the Alabama law that addresses bullying and harassment and prevention of that and having policies in place. But oftentimes we forget, even administrators and educators, that there are other laws that come into play, that the rules and the procedures are different for each of those laws. And so anytime somebody is alleging bullying, I hope that our administrators and our educators are also thinking about, what does the IDEA require us to do? What would Title IX require us to do? What would OCR require us to do? But to highlight the recent changes in the Student Harassment Prevention Act in Alabama, in 2018, there was a student named Jamari Terrell Williams. He was a Montgomery fifth grader, and he took his own life after he was bullied by students at school. And his mother has been a very active supporter of bullying prevention since this happened. She started her own foundation. She's working with city officials and schools and churches. And one of the things that she did after this happened was go forward to the legislature. And prior to 2018, our local Alabama Act just discussed harassment. We didn't have the term bullying in the law. So in 2018, we expanded the Harassment Act to better identify and define bullying, to include the definition of bullying, cyberbullying, and to talk about how bullying now and the things that administrators are supposed to look into now does not just include actions and bullying that happens on school property, but it also includes actions and violence that might occur off school property. And thankfully, Chris has hit a topic that concerned me when I first read this law, was how does that then converge with First Amendment issues? If we now have to go in and investigate and intervene with any kind of cyberbullying that might occur off campus, when we have First Amendment student rights at play as well. But we're going to go into that. So I'm going to just hit some of these as a highlight and highlight the main issues. The important thing with the Alabama Bullying Prevention Act is it is much more specific than our federal laws that we look at in regards to what is bullying. Alabama outlines for administrators and educators and parents that bullying is a continuous pattern. So we've got that repetition that is required. It's student on student. It's intentional behavior. It's not, I didn't mean to hurt your feelings. It's on or off school property. It's cyberbullying. And importantly, in the Harassment Act and the Bullying Prevention Act, the Harassment Act previously, the act tells the school board that they are to define in their policy what categories and characteristics that the bullying would have to be based on that would be covered under the Act. So if you look to the Alabama Education Department's model policy, they identify race, sex, religion, national origin, and disability as those characteristics of a student that these continuous intentional behaviors are occurring. So if bullying is occurring and it's not based on race, then it wouldn't technically fall under the bullying definition under the Alabama Bullying Prevention Act. Our local policy and your local policy may further define additional characteristics of students. So you may decide as a board, and your administrators may propose that we further elaborate that we're also going to protect the categories of students who are bullied based on their gender identity or their sexual orientation or their marital status or whether or not they're homeless or not, or maybe their socioeconomic status. So it's really important for you as board members to define for yourselves and as a school system, what characteristics are we going to say that we are going to define as bullying of a student in order for our educators to take action under the Bullying and Prevention Act. To constitute bullying in Alabama, it has to be a pattern of behavior that does any of the following. So it's not an and, it's an or. It places the student in reasonable fear of harm. It substantially interferes with their educational performance. It substantially disrupts or interferes with the orderly operation of school. The bullying is so bad it's causing kids to riot or it's causing fights to break out. It creates a hostile environment, and it's sufficiently severe or pervasive enough to create an intimidating or threatening educational environment. Now we go on in the Act and define what is hostile environment. And I think what's important here is it's not just the student's perception that this is a hostile environment. It is the student's perception, the victim's perception, and whether a reasonable person would find that behavior objectively severe or pervasive enough. So it's an administrator deciding, yes, the perception of this student is that bullying is occurring, but would a reasonable person find that this is bullying as well? So just a summary of what is prohibited under the Alabama Bullying Prevention Act. The Act itself prohibits any kind of bullying and says that no student shall engage in it. It says it's on or off school property. So we're going to go into it, but we want to have a sufficient nexus to the school property and to the school day. The Act prohibits any kind of retaliation for those that may file a good faith complaint that bullying has occurred. The Act requires that the board have complaint forms and a board policy. It even goes into detail and requires that those forms are to be posted prominently on the school website, in the school office, and in the student handbook each year. And then it requires that there's different plans or programs and educational programs in place to give parents access to resources for bullying. All right, you can go online if you don't have, if your board has not adopted the model policy yet and changed your policy from the Harassment Act to define the Bullying and Prevention Act. You can go online to ALSDE's website, and they have that model Bullying Prevention Act policy that you can adopt. And there's different requirements in the law of what your policy has to contain, and that model policy on the website has all those elements included in there. And I'm going to go through those, and so we can get to more of the details. All right, so the duties of the schools under the Alabama Bullying and Prevention Act is that you are to develop and implement evidence-based practices. And I don't know how often as board members y'all have heard that use of that phrase or what that means, but essentially it means you've got to have, you can't just come forward, your administrator shouldn't be just coming forward with some new idea. Evidence-based means, has it been researched? Has it been used? Are there articles about it showing that it does have a positive impact and that it actually works? So we want to make sure that our school systems have evidence-based practices to promote an environment free of harassment. We want to make sure we have evidence-based practices to prevent harassment. We want to incorporate that sensitivity of others and anti-harassment and bullying into our education curriculum. A lot of times we have our counselors incorporate that into their monthly counseling sessions that they have with students. And then also there's a requirement that they, under this act, that administrators report statistics to the local board regarding acts of violence and give the board a summary of those reports. All right. Sorry, I'm like trigger happy with my keyboard screen today. All right, so just in summary, we want to make sure we have a policy. We want to make sure we have assemblies for students and faculty at the beginning of each school year. All of our schools here in Baldwin County, they're very good about holding that anti-bullying assembly at the beginning of school year. The act requires that you have a committee, that you convene the committee and the students, and you're monitoring bullying, whether that's through student surveys, and that you're looking at maybe hot pockets of bullying issues. You want to make sure you have copies of the complaint forms readily accessible on your website and in the student handbook. And then the new requirement was preparing a non-exhaustive list of the specific personal characteristics of a student, which may often lead to bullying, and you can access that on the state's website as well. All right. The other little caveat right at the end of the Alabama Bullying and Prevention Act is a section under the act talking about suicide prevention. And I won't go into all the details with this one, but it is very similar to the Bullying and Prevention Act in that there are policy requirements that are required to be adopted by the board, put in place to prevent suicide and provide resources and crisis intervention to parents and students. Our policy, so as a board member, make sure that your board policy has something in there regarding suicide prevention and how administrators and counselors are going to respond to student reports of suicide. The last Alabama law I want to highlight is one that I think sometimes gets overlooked, which is the anti-hazing law. Something just to highlight with this law is our bullying and prevention law talks about student-on-student harassment. Important to me in the hazing law is it's not just limited to student-on-student. It is a complete ban that no one is to encourage or engage in hazing of another student. And primarily they talk about how that is limited to those actions that are taken in situations created in connection with initiation into or affiliation with an organization. I think sometimes we forget about hazing. It's not the hot topic anymore. But I just throw it out there as because it applies to teachers as well, educators and coaches and administrators are not to engage in hazing as well. And there's a criminal piece to this. If you're ever found to have engaged in hazing, it is a Class C misdemeanor. So real quickly, I'm going to scroll through these individual slides and come to the Office of Civil Rights jurisdiction. So not only could a parent come and file a lawsuit for bullying and allege, that the board is liable or the individuals are held liable, parents also have access to filing an Office of Civil Rights complaint. And the Office of Civil Rights, as I tell my clients, you never want to open that door to their investigation process. Now, they're very nice to deal with, but they have jurisdiction over a lot of different issues. And when they find one issue, they have jurisdiction to keep looking. So anytime we have bullying related to race or gender or disability or religion, it may fall under one of these categories. And I tell administrators that it's not enough just to say they didn't fill out the complaint form under Alabama law, so I don't have to look into it. So with Title VI, if you've got racial bullying or harassment, you're going to want to make sure you respond as you would under a Title VI claim of racial-based discrimination. Title IX, of course, is our gender-based discrimination law. And then Section 504 and the IDEA, anything that deals with someone with a disability would fall under OCR's jurisdiction as well. And importantly, OCR has said, whatever the rule is in the case law as far as what you have to do or not do to respond to bullying, OCR says school staff have a duty to recognize it and address a hostile environment, even if there's no complaint filed. So they don't have to put it on a written form for the Office of Civil Rights to have said that the administrators should go in and address it. And importantly, the standard is if an administrator or an educator knew or reasonably should have known. And of course, they're always looking at it going backwards and Monday morning quarterbacking. But OCR has said it doesn't matter if the misconduct is not defined as bullying under your local policy. It doesn't matter if it's not defined as bullying under state law. It doesn't matter that the student or the parent hasn't actually formally complained. If a teacher or a principal knows or should have known that a student is being harassed based on gender or disability, then the school system has a duty to address it and look into it. And here I just go through what are the different definitions of bullying, and I think you see here where it's more of a broad definition of what is or is not bullying, and there's no hard and fast rule. And unfortunately, a lot of times OCR comes in and tells us that we should have considered it bullying when we might not have felt that it rose to the level of that repeated repetition of creating a imbalance of power. And I think it's important to, at that point, when you have OCR to come in to consult with your board attorney and to be comfortable in saying, you know, this may have risen to the level of something that was a behavior that we needed to address, but it's not bullying and it wasn't disability-based harassment. I'm not going to bore you with going into details of a free and appropriate public education. I know sometimes when we go into special ed world, I see like eyes glaze over, and fortunately today I don't have to see eyes glaze over, but just know that your educational professionals and your teachers and your administrators, OCR has said not only do they have a duty to address the bullying that is going on and to investigate the bullying and to look into disciplining the student that has done the bullying, but also for that victim, if they are identified under IDEA or Section 504, OCR has said you have a duty to also address their free and appropriate public education. We may need to meet as a team and discuss what sort of educational services need to be put in place or revised because this student was a victim of bullying or harassment. Which, what does that do? I'm going to scroll through this. But the effect of that is due process. If the parent does not like the decisions that the 504 team or the IEP team have done in order to address the bullying on the victim, parents have another avenue of being able to file a due process under either Section 504 or IDEA, and that can cost money. So we want to avoid that, and unfortunately, OCR has set us up for having to deal with that. Just keep in mind that sometimes the student who has the disability is the bully, and I hear that a lot when I go into schools. You know, with certain behaviors that are aggressive with children with a disability, it's, well, they're just being the bully, and I often say to them, you know, we still need to look into, and OCR has said we still need to look into, if that student has a disability, we need to look into whether there are some behavioral interventions we can put in place to prevent that child from being the bully. Let's move on. All right, summary of what OCR says is your obligation. Has to be a team decision. You need to get together and decide as a team whether or not for the bully, it's been a manifestation of his disability. If it is the student with a disability that is the victim, we want to consider whether we can put some additional interventions and counseling in place as a team. And it may include parent, staff, student training regarding accepting of others, or maybe some behavior intervention training. Just a quick overview. You know, I think as we talked about in the beginning, lawsuits are always a hot topic in the back of school board members' minds, as they should be, because they can be costly and nobody wants to be sued. I think importantly, there's a difficult and high burden and threshold for parents and students that file lawsuits under different bullying laws. Typically, the standard for holding individuals accountable and liable when a lawsuit is filed is whether or not someone was deliberately indifferent. And I always describe that as you've got to be like really bad and just completely turned a blind eye to what has gone on in order to be held responsible. But keep in mind, that doesn't mean that OCR is not going to get you on the front side or the back side. And Chris highlighted this, so I'm glad he went into this, but one thing that is a hot topic with bullying, especially since the bullying laws have been revised to say that the school system has a duty to look into off-campus behavior, is you still want to consider, did that cyberbullying or was that off-campus behavior, does it have a sufficient nexus to the school environment? And what I've told my counselors and my administrators is, it's so hard these days not to say that it doesn't have some sort of nexus to the school environment. And I do think that there is a difference between investigating and remediating and taking action to help the victim feel safe versus deciding to take discipline against the harasser for that off-campus behavior. And I always say, before we're going to impose some sort of harsh discipline, and we are not, if we're not going to go through our graduated consequences, that they need to consult their board attorney. And so that's what I would encourage you all as school board members, for that to be in the back of your mind, that we know with these First Amendment issues and our duty to investigate cyberbullying, that before we take that discipline against the perpetrator, we need to consult our board attorney or make sure we've got a substantial disruption and a sufficient nexus to the school environment. And I've given some examples of district liability where they've been held liable and also where they've been held not to be liable. And I'm gonna breeze through these cases, but one I like to highlight, which is from the 11th Circuit, I highlight to our administrators because I think that they feel like I'm supposed to have an environment that's completely free of bullying. And I tell them, you know, at least under IDEA in Section 504 in our circuit, which is the 11th Circuit, the courts have recognized that you don't have to have an environment completely free from bullying. We can't always prevent every piece of harm that is done to our students. But what the cases are looking for as far as administrator liability or school board liability is, did you do something? And were you taking steps to try to prevent the harassment, to try to remediate the student victim? Were you changing the IEP or the 504 plan? And were you working through some graduated consequences with the student aggressor? And at the end of the day, that may be an environment that wasn't completely free of bullying, but you weren't deliberately indifferent. So your takeaways, as I highlighted, and I promise I'm wrapping up, is that we just, as board members, I want you to just be aware that there's overlapping definitions, and within those overlapping definitions of bullying are overlapping procedures and things that we need to do. How we might address something under state law is going to be different than how the Office of Civil Rights might tell your administrators that they should have addressed it. And then with that is the different exposures to liability under the different laws. We know the standard is very high when an actual lawsuit is filed, but when OCR comes in, which can be just as costly, the standard is going to be a little bit lower. And one thing I like to tell administrators is that the label does not dictate the response. Sometimes I go in and I talk to them and they say, well, it's not bullying. It's just not egregious. It's that this kid just can't tolerate being picked on. And I would say that the label doesn't dictate the response that you should do. What should dictate the response is the nature of the conduct, whether it's harassment or intimidation or bullying or just being mean. Is it based on race, gender, disability, some sort of identified characteristic? If so, under the civil rights laws, we need to look into it. And the things that we want to be aware of as school board members, if you're hearing some level of grievance with bullying under your board policy, is, did your administrators and educators respond? What was their response? Was it reasonable? Was it timely? And then we want to make sure that our educators are addressing the individual needs of the victim. As school board members, I would hope that you are knowledgeable about the different definitions of bullying. The characteristics and warning signs of bullying. I know you guys field calls from parents that are upset and feel like their children are being bullied. And just to be aware of cyberbullying injunctions. They don't necessarily affect the school system, but a lot of parents these days across the country are going into the actual court world and asking the courts to file an injunction against one student versus another to stop bullying my child. And so there may be a situation where the school is forced to have to implement those injunctions and at least supervise whether or not there's continued bullying going on inside the school day based on the fact that a judge has ordered that these two people are supposed to stay completely separated. And I always like to highlight that the best way that you can, as a board member, prevent bullying is to be a role model. And I hope that all of your boards get along well. But we want to avoid out in the public and on social media and just be a role model and don't be the bully. And I know none of y'all are. I just want to highlight that. And then not be deliberately indifferent. You as a board member, if you receive a concern from a parent that indicates that a student's bullied, I think you reach out to your administrator and make them aware. My board is great about doing that because you don't want to be accused as your own in your own role as turning a blind eye to the bullying. And just to make sure your policies and procedures comply, there's been a recent case where they alleged that the harassment, the board had not adopted the updated bullying policy. We'll have to see how that goes, whether or not that will be held against the board, and review those policies and procedures. Now, one of the questions I got from a board member, and I'll just highlight it and then we'll go to questions, was how do we as a board respond to bullying and help set the tone for bullying in light of the fact that some boards don't have any role in the disciplinary process. And I think I would say, I think the number one way you can do it is by being a role model, being an inquisitive and a proactive board member in asking those questions to your administrators and to your superintendent about how do y'all address bullying in your schools? Is it a zero tolerance policy? Do we work through graduated consequences? I think it's really important to support training of our educators and our administrators on the different laws that apply. And I also think it's important to be supportive when our administrators are bringing forward programs that help promote a positive school climate. And I'm a big proponent of PBIS. One of the questions was, how do we keep kids in school that maybe are the bullies? And I think that is setting an example that we are going to implement research-based programs that are based on positive behavioral interventions and support versus negative consequences and discipline. So we are responding to the victims and we're also responding to the bullies through research-based training and supporting those programs with our educators of providing positive interventions versus negative. I think that's all I have to cover. I've got you some resources on your handout, and I will take questions if there are any, and I'm sorry for going over.
Thank you so much, Sarah. We do have a few questions. The first question is, if two students plan and execute a bullying act together, how do we address this?
Well, I think kind of how Chris highlighted, I think each student is an individual. And I think that when OCR asks you to look into each student, they want you to apply your discipline equally, but yet individually. So I like to see that if we're going to deviate from the same consequence for both students, what is the rationale for deviating and imposing different discipline for each student? And I tell them, if you're going to deviate, just make sure you've written down those reasons. So, I would suggest that, you interview and you document that interview and you talk to other people. And if you're going to discipline, that you keep them consistent, but if you're going to deviate, you document.
Okay, thank you. And the next question is, how can we expect teachers to keep children from bullying each other on the playground or in the bathroom? Is the goal to prevent the bullying or to respond to it?
I think it's twofold. I think that the goal is to prevent the bullying, and I think that's where good programming with positive behavioral interventions and setting a good tone and climate among the school system and the campus from the beginning of the year and throughout the year with developed programs and counseling that you do with your and social skills training. I think that helps curb the bullying. I do think it's preventative. I think that the case law supports that you don't have to 100% prevent bullying, and we're never going to be able to. So I also think it's responsive, and it is intervening when we see it occurring and addressing it with actions towards the victim and the perpetrator.
Okay, and our last question is, you mentioned other characteristics that we can consider. What about a student's height or weight? Can these be protected characteristics? Excuse me. Someone was talking to me at the same time.
You know, they are not identified categories of protected status under typical civil rights law, but I haven't seen any prohibition that says as a board, you could not decide that one of the categories you were going to define in your board policy was, you know, discriminating and bullying a student based on their weight or height. I will say, opening the door to those additional characteristics that maybe aren't typically highlighted in civil rights law does open to the door to the fact that maybe not all your administrators and educators are going to be aware that they have to intervene and look into that and treat it as bullying. And so then you set yourself up for having a policy and not following the policy. So in my situation, I think I would probably advise my client that let's stick to the categories that have typically been identified as those civil rights protected categories, but there's no prohibition to extending that umbrella.
Before we go, I want to thank Chris and Sarah again for being with us today. I also want to thank all of you for your participation, and we hope you found this webinar to be useful. Join us on June 10th for part 2 of AASB's virtual Summer Law Clinic webinar series.